mention one matter.
Yes, please.
Pertaining to the list of the Honorable Division Bench comprising of Honorable Justice Rajashekhar Mantha and Honorable Justice Ajay Kumar Gupta. My lord, the tender process has been stayed by an order passed by the learned single bench. My lordship, this was order was passed on 17th. I took leave to file leave to appeal because I was one of the participants in the tender process. But lordship, I was not made a party. Tender was ongoing process, and this order was passed. Lordship, it's a pure question of law. This can be disposed of, lordship, which can be taken up at any point of time today. The leave was granted yesterday, and to move the matter today. Lordship, it's appearing as item number 2 in Honorable Justice Mantha's division bench's list. My lord.
There is a stay.
There is a stay to finalization of the tender process, lordship. That
Can wait till Monday.
the question is, lordship, the this order is completely perverse.
That is
Lordship.
on merits. We are on urgency. There is only a stay. It can wait till Monday. It's not that something is going to happen today.
If the finalization process related to the ferry ghat, lordship,
Can
the
wait till Monday.
public service would be affected, lordship. That is the
2 days. Yes.
My lord, for inclusion in the list and tagging me see yesterday's item 2, wherein I have
Oh yes, give it. That we have fixed. Just that in that. So this will come with the other case. Okay. Yes.
I have a lordship's kind leave, my lord, to mention, my lord, this matter, my lord, for upgradation. My lord, this is at item number 148 of the day's list, my lord. This is a, my lord, septuagenarian gentleman, my lord, he's ailing. My lord, this is for his retirement dues. My lord, similarly circumstanced, and my lord, even
You wait, please. Wait.
The lordship leave, my lord, to mention this matter, my lord, for urgent hearing. My lord, this matter, my lord, the matter appeared yesterday before the tribunal. My lord, the learned tribunal fixed the matter on 26th, although 24th is the date for study for the purpose of commencing my course, my lord. But the tribunal opined, as because the respondents didn't appear, my lord, I have served the notice. The registrar said within 48 hours is to be served. I have served the notice 7 days back. As because none appeared.
24th is the date of commencement of the course.
Yes, my lord.
For what?
My lord, I am seeking study leave. My study leave was rejected by the authorities. My lord, I on the pretext that 330 incumbents were given TR.
What we want to know is why you can't join a few days late.
My lord, the online registration of that course would be over by 24th. My lord, if I do not go there, my lord, I'm nowhere. My lord.
File it.
My lord, your lordship, can you leave to?
You have given an undertaking.
My lord, I've got the certified copy.
So everything is there.
My lord, only thing, my lord, let that be appear on Monday. My lord.
File it. Then inform. We will.
My lord, unless your lordship grants me leave, the GP office won't accept.
All right.
The government PD's office don't.
File it. We are granting leave. Let it come on Monday.
Monday at 2 o'clock, my lord. Monday.
Why do you come at the last day all the time?
My lord, I waited till tribunal. My lord, tribunal. Yesterday, the matter was there before the tribunal. My lord, tribunal, although my lord records that affidavit services filed.
All right, anyway.
But still,
you file it.
My lord, the petitioner is a wife of.
Wait, senior counsel is mentioned. Okay. Yes.
The petitioner is a wife of mentally incapacitated land department employee of West Bengal government, seeks compassionate appointment. Despite the 3-member inquiry committee.
Compassionate appointment. What is it? It is pending at which serial number?
My lord, the matter is listed in today's list as item number 139.
139. Why are you mentioning, sir? Wait some time. This is hardly any. Yes, call the list.
item number 2.
But even though there is no dispute, my lord, I think, my lord, we were not able to explain, my lord, correctly to the learned judge. The writ petition was dismissed on the ground, my lord, that there are disputes. Questions of fact.
Give the memo. Give them.
The writ petition against a nationalized bank. Sir, aware, my lord, that
Give them. (2017) is there any interim order obtained? What is the impugned order's date?
21st of June 2017. The very hapless condition, I sold goods, my lord, to a private party. The goods were required to be paid for through a letter of credit. Now we have no difficulty with that. Whatever was the letter of credit, the terms will apply. I delivered the goods. The purchaser did not raise any disputes, nor is he raising any disputes today. After the goods were received by the purchaser, the bank, my lord, suddenly alters the terms of the letter of credit on its own unilaterally. And then, my lord, despite my bank making over all documents to it, it refuses to make payment. So the situation, my lord, is quite, my lord, absurd. Purchaser has received the goods. Purchaser accepts the goods, does not, my lord, raise any dispute. Bank, my lord, after delivery of goods, after the transaction is over, purports to, my lord, unilaterally alter the terms of the letter of credit, and after 9 months refuses to make payment despite every protest, my lord, from my bank. My bank said that you have to make payment. These were the terms, but it does not. I file a writ petition. I go to the ombudsman. Then I file a writ petition. Writ petition, my lord, is dismissed on the ground, my lord, of disputed questions of fact. I'll show your lordship, my lord, there is no disputed issue in the writ petition. May I, my lord, read the order at page 116.
My lord, my first objection, whether it is a public or a private. Whether it is a public dispute or private dispute, whether this, in this case, Article 12 will apply for or not.
Which bank?
Union Bank of India,
Nationalized bank.
nationalized.
So he is aggrieved by some
The contract is a private
inaction on the
contract.
part of the nationalized bank.
No, a private contract, my lord. I have got the judgment of the Supreme Court. It is a private contract.
Yes.
Not only that, he has got no connection with the bank. Borrower, bank and borrower has applied for loan, and my lord, the LC was granted. That is the case. And that matter, borrower has defaulted in making payments, and that matter is pending before the Debts Recovery Tribunal.
So that is the real issue. Let's please see the unfairness of the situation. Letter of credit, my lord, is a way of ensuring 100% payment to me if I without any blemish, my lord, deliver goods. So it will ensure once goods goes, I'll get my payment. Lord, bank issues, nationalized bank issues a letter of credit, so gives me that security that if you deliver goods, if all documents are in order, I will make payment. Now, my lord, I give goods. There's no dispute. Borrower accepts goods. No dispute. I give the documents, my lord, to my bank. My lord, there's no dispute about that. My bank finds, my lord, all the documents in order, sends it to, my lord, the Union Bank of India. Now, just because Union Bank of India's customer has defaulted, he refuses to make payment to me, as is now, my lord, after 12 years evident. So this is, my lord, gross dereliction, my lord, of their duties as a nationalized bank. Now, my lord, this objection comes up today that the writ petition is not maintainable for the first time in appeal. In the impugned order, my lord, your lordship would not find this objection taken. My lord, I'll deal with the objection. May I, my lord, show your lordship page 34.
Of
My lord, of the stay petition, my lord. Lord, please see, my lord, this is the letter of credit. It is dated, my lord, 10th of December, 2013. The irrevocable document.
a petition is can number
Can number 8394 of 2017.
page 34.
34, my lord. applicant, my lord, is Eureka Tradecom. And, my lord, who's, my lord, a private respondent here, respondent number 4.
You are Plastipack.
I am, my lord, Plastipack. The proprietor is suing. Now, my lord, credit available by the beneficiaries drafts drawn on the Union Bank of India and marked drawn under such and such for, this is right at the middle of the page, for 100% of the invoice value at site days, 90 days from the date of transport documents accompanied by the following documents quoting this credit number. And Milord, the documents are signed invoice, including taxes and duties in duplicate copy, works value of goods, then other documents, bill of exchange, signed invoice, copy of LC, evidencing shipment and dispatch of goods. Now, my lord, after this, Lord, please turn over to the next page. This is, my lord, second heading, special instruction to negotiating bank. Negotiation should be marked separately on this documentary credit, should accompany the draft which exhausts the credit. Negotiating bank must send the full set of documents to us in one lot. A, B, we shall remit on due date you claim on us. Additional conditions, all advising negotiating bank's charges are opener's account, usance period is on opener's account. So, Milord, it's an unconditional agreement to make payment upon, Milord, documents being made over. Now, Milord, please come to page 36. They, Milord, amend the letter of credit once. And there is, Milord, no dispute. We accept this. 23rd of December 2013, that the amendment is credit available by beneficiaries draft drawn on Union Bank and mark drawn under UBI for 100% of the invoice value at site. EA from the date of bill of exchange accompanied by the following document. So, Milord, the shipment dispatch documents, Milord, they amend. There is no difficulty. Now, Milord, after 23rd of December, on 30th of December, Milord, we dispatch the goods and the beneficiary, Milord, receives the goods. That is at, Milord, page 31 and 32. 31 is the challan. We deliver the goods. And, Milord, there's a delivery endorsed. And, Milord, the receipt, Milord, is at page 32. Issued by, Milord, the private respondent. They say to whom it may concern, this is informing you that we have received the material from Plastipack, Vide invoice number such and such, ILC number such and such. And on the next page, page 33, is the requirement under the letter of credit, the excise invoice cum tax invoice, which, Milord, is raised by us. After this, Milord, this happens on 30th of December. So I become entitled, Milord, to put in the documents with my bank. My bank will give it to his bank. Milord, that is, Milord, my learned friend's clients, and get, Milord, the money. On 6th of January, which is, Milord, 7 days after goods are delivered, transaction fructifies, page 37, Union Bank issues, Milord, a unilateral amendment. Let me see page 37. At the request of the applicant Eureka Tradecom, we have made the following amendment. Credit available such and such to be read as credit available by beneficiaries draft drawn on such and such of invoice value 90 days from the date of bill of exchange accompanied by the following document. And, Milord, suddenly, Milord, a list of 15 documents come in. On the same day, Milord, we open, Milord, a bill of exchange. And, Milord, please see page 39. The buyer endorses my bill of exchange at the bottom left hand for Eureka Tradecom Director accepted. All documents are accepted. Goods are accepted, documents are accepted by the buyer. Now, my lord, we on 16th of January, we, my lord, write to the general manager giving all the documents and we request, my lord, for payment. We give it to our bank has to give it to his bank. On 8th of December, I'm sorry, my lord, please come to page 41. The date is wrong, it's 11th December. With reference to your letter, dated such and such regarding the caption matter, and letter numbers are in this regard. As per ILC terms and condition, applicant bank should remit the funds to beneficiary's bank within due date of the bill. But instead of remitting the funds, you have returned our documents on 8th December, after 8 months from the due date of our discounted bill. So, my lord, January, documents are given, they sit over it for 12 months, 8th of December, they may not return, which is recorded by my bank. Now, my lord, please come to page 44. I won't show every document. I write to them, but page 44, my lord, my bank, which is Syndicate Bank, writes to my lord Union Bank. And my lord Union Bank, my lord, my learned friends, clients had raised certain, my lord, frivolous issues. That also, my lord, my bank deals with. Transport receipt not enclosed, receipted delivery challan not enclosed, credit report, insurance policy not submitted. And my bank clarifies that this is all, my lord, incorrect because buyer has received and accepted the goods. And in any case, this was not a part of the original, of the conditions in the original letter of credit. My lord, please see one. This clause included in the amendment of your LC on 6th of January. But the material was already shipped by the seller and received by the buyer on 31st December 2013 with good condition, certificate enclosed. Subsequently, the required documents were prepared and submitted as per your original terms and conditions. Receipted delivery challan not enclosed. This clause also included in the amendment of your LC on 6 January, as mentioned above. When the buyer has already received the material with good condition, then this clause is redundant. Then credit report, same thing. And, my lord, my bank tells Syndicate Banks writes to, my lord, them saying that please pay. Now, my lord, this goes on. Ultimately, my lord, we go to the ombudsman. You know, series of letters. It goes to the ombudsman. Ombudsman says, I can't do anything. And, my lord, we file the writ petition. Now, my lord, two things, my lord, may I humbly submit. My lord, we've also complained to, my lord, the Reserve Bank of India. Reserve Bank of India deals with our complaint. Your Lordship will kindly see, my lord, page 67. Yes, yes, my lord, page 67. That is Reserve Bank of India writing to, my lord, tell us that the complaint, my lord, stands disposed of in view of Union Bank of India's response at page 68. My lord, please see page 68. In this regard, second paragraph, we wish to inform you that our credit department had already taken up the matter with the branch, Baliganj branch, vide letter number such and such, informed our office that payment against the documents of the LC referred to in the complaint was declined by them for the following discrepancies: 1, 2, and 3. What are the discrepancies? Transport receipt was not enclosed. Receipted delivery challan was not enclosed. Credit report and insurance policy not enclosed. Now, these three requirements are not requirements under the letter of credit or the First Amendment. These are, my lord, requirements under the 6th January 2014 Second Amendment, which is unilateral after goods have been delivered. In any case, my lord, that's what, my lord, my first argument is that terms of a letter of credit cannot be unilaterally amended by the bank. No contract can be
That
unilateral.
issue, therefore, the honorable single judge has said has to be examined and established by you, whether it is unilateral or not. So therefore, for a writ, obviously this is, it appears prima facie to be.
Not minted. Well, let me try and persuade your lordships very quickly with the judgments. That if I cannot change your lordship's mind, my fate, my lord, is sealed. But I'll be very quick.
Yes, please.
But the main borrower was not brought to
Yes.
this court. They went, I do not know whether they are served or not.
Since we are not going into, so on the issue of maintainability, the honorable single judge has refused to exercise jurisdiction. This is quickly,
Sir, just 5 minutes, I'll complete the
Yes.
judgment.
10 judgments you have given. us.
No, my lord, I'll cite very quickly. My lord, so, my lord, my arguments,
Yes,
my lord, my arguments are this. Number one, my lord, is that when bank, my lord, under RBI guidelines, under, my lord, the laws of banking in force, a letter of credit, my lord, is issued by a bank to
Yes.
guarantee payment. If, my lord, a bank walks out of its letter of credit, it becomes, my lord, an impossible situation. The banking sector will fail. It is with this comfort in mind that, my lord, once LC was opened, I, my lord, delivered the goods. Now, my lord, the cat is out of the bag today. For after 14 years, my lord, my learned friend today for the first time says that the borrower, his borrower, is a defaulter, which is why, my lord, he is not paying me. Because he knows if he pays me, he is not going to be able to, my lord, recover the money. This, my lord, a bank should not be permitted to do. Once you have issued an LC, you have to honor it. That's the basis of our banking jurisprudence.
actually what is on record is there are 3 requirements which they have found not fulfilled.
Yes,
This is in terms of the conditions dated 6/1.
yes.
That 6/1 condition was never objected by you. You were conscious of these requirements all throughout.
Let me, my lord, deal with this.
So therefore, whether it is unilaterally or it is bilateral, these are issues of fact. Therefore, the honorable single judge has said that you may establish it, but in an appropriate proceeding. That will have to be between you and the receiver of the goods.
Now, my lord, 2 things. My lord, may I just deal with it? Absolutely, my lord, correct. May I just deal with this issue?
Yes.
Number 1 is 30th December 2013, goods are delivered. After delivery of the goods, in terms of the letter of credit and the First Amendment, it is inconceivable that a Second Amendment be made by a bank. Because contract has already happened. I have delivered my goods on the basis of LC and 1 amendment. So you
That is
can't-
your stand. That cannot be accepted in view of the bank's amendment communicated to you on 6.
Yes. Now, my lord, what is the
Not objected, never objected.
what is the effect of this? My lord?
You had the option to object at the point that amendment was communicated to you. You never did that. Your bank kept pursuing the matter.
No, we pursued the matter on
Correct.
that basis.
You
but
did not object to these conditions. That was the point at which you could have raised this dispute that these are bilateral, no, unilateral.
Correct.
We don't agree. Now, so it's a bit late in the day to say that it is unilateral, not agreed by us.
But my lord, this was
So whether we should make any observation on merits or whether the honorable single judge, therefore we are only asking you.
but my lord, even then, even if your lordship takes this into account, admitted position is I never agreed.
We don't know. There is no objection on record.
Bank has to show that.
You are coming to the court, you have to establish your case that it is unilateral.
Can't my lord establish the negative. My lord, we cannot
But you
say
can
that.
surely give on record that this is an objection I had raised. There is no question of establishing a negative. That's not what we are asking you to do.
Yes, I understand. But before the objection comes the question, are you entitled to
We
unilaterally?
don't know. That is the issue between you and that buyer. That is why we are saying. Again, we are in the writ jurisdiction. Therefore, we are saying.
Difficulty is not, it's a 2013 issue. We are in 25.
That is why we have been hearing you. We see that, but after 2017, you have waited so long. You could have taken steps.
You are hopeful that
7 years has passed by, 8 years now.
the other issue is even if this is not Miller taken into consideration, when the buyer has received the goods, the thing is, Miller, this pales into insignificance when the buyer receives the goods and doesn't object. Just because
Therefore, again, between you and the buyer. That is precisely what we are saying. You have to, it has to be in an appropriate proceeding. Therefore, the Honorable Single Judge in our prima facie opinion is correct. And therefore, he has not entered into the merits of the issue.
that if your lordships feel that way, Miller, then I'll go and file a suit.
You have options, you have other options also.
But nothing else will apply. I have exhausted ombudsman. I have exhausted Miller writ remedy. I wanted to Miller do the appeal and I've tried.
No,
Your
because
lordship,
of the delay we were trying to see, but it appears to.
kindly only Miller, in that event, Miller, I won't push it further, Miller. Kindly, Miller, send me to a suit, Miller, and give me the benefit of limitation. Otherwise,
Yes.
Miller, it will
Well,
be very unfair.
2000,
That you will be entitled to otherwise also under the Limitation Act.
But
Needless to say, we have understood what you are saying. Yes.
Well, 2014, well, this incident was happened.
All,
Writ application filed on 2016.
yes.
And 2016, 13 to notice was issued. Well, it's a clear collusion and conspiracy in between the,
All right.
well, the buyer and the purchaser.
After
Item number 3.
And for the petitioner in this, the learned senior hasn't come to court today, Your Lordship. I'm just praying for not today. Matter may be taken up on Monday.
Not today, yes.
Hearing on behalf of the respondents. Four.
I think to appear on behalf of the respondent. My lord, I have received the brief, my lord. I need certain instructions from the department.
Lordship, only one thing is that, Your Lordship, petitioner, Your Lord, seeking compassionate appointment on the ground, Your Lordship, on the death of the father, Your Lordship.
So it has to be without any instructions.
Yes, Lordship, but the Lordship, I find, Your Lordship, the incurable defect in the petition. So I'm seeking liberty, Your Lordship, to withdraw the petition and file a fresh, Your Lordship. Since, Your Lordship, there is a...
As prayed by learned counsel.
Five. For the petitioner, my lord. My lord, I find that service upon one of the respondents is returning back, my lord. So let the service be complete.
Which respondent?
On the record of this is an
Which respond number?
respondent number 3. So
Full stop. The learned counsel for the for 2 weeks comes to which date? You want on 9th as list on 9th.
My lord, item 6, I am for the petitioner. My lord, your lordship has directed the state to file an affidavit. My lord, and subsequently they have also prayed for extension, which your lordships were pleased to grant. My lord, but till today we have not got the affidavits from the state. Mr. Bishopbrata Bosu Mollik is representing the state. My lord. Kindly pray for a short Passover. My lord.
Not today, later. Come.
Seven.
Please, my lords. Objection of filing affidavit in opposition, Your Lordship. A copy is being served.
Please, my lords, I pray appear on behalf of the petitioners. The instruction to file this was on 19th, my lord, on 9th of June, my lord. We followed up. According to my learned junior friend, she was saying that they have tried service upon us, but we did not
Your
get any
Lordship, there was no follow.
initiatives.
So we
You're
have
at mercy.
served a copy.
What do you mean? Today she is filing an opposition. You want to file a reply or you don't tell us? Forget about how it. How is that relevant today? That it has been done after a few days delay or whatever.
Also obliged, my lord. At least a week to reply to this.
Yes, as prayed by petitioner's counsel.
Serving
17th of June. ঠিক আছে।
27th June.
22nd June. July.
Much obliged, my lords.
June. 1
26th.
week. 8. Reasoning.
My lord, না না ডাক্তার না আপনার আসির আহমেদ আপনারা এফিডেভিট দিয়েছেন। My lord, on the 17th, my lord, I have received the affidavit in opposition. Lord, I am seeking, my lord, 2 weeks time to file 2 weeks, my lord, to file affidavit in reply.
আমার এভিডেভিটটা দাও, আমার এভিডেভিটটা দাও।
Number 8.
নাসির আহমেদ। Data. This is my evidence. অন্য ব্যক্তি দেখুন।
You are relying on which rule? A police personnel who dies in line of duty, what is your department's rule or provision regarding payment of any?
I see the date of death. Well, that is a two contradictory judgments. One for the same division bench, 3 judges bench judgment, 2020 volume 7, NC Santos versus that. On the date of consideration of the application, rule prevailing at that time, that should be considered. But 2021, another division bench of the Supreme Court said, no, when the death took place, that is the relevant point for consideration.
This, as we gather from our last order, this is not a case of compassion simplister. It is their case that he has died in the line of duty.
Line of duty.
In that case, any circular rule is in vogue, and something must be there.
No. But only that appointment on compassion ground.
So you have said that in as regards a person falling in the line of duty, we have nothing.
Nothing. But
where is that statement? Show us.
I see paragraph 4. Then 4B. First, 30th of June 2006. Then, if it is taken up that 2006 died, then 2006 notification was once over.
Our specific query in the last order is What is the provision in the case of a person who dies in the line of duty?
Kind of duty.
What have you said on that point? Show us.
Several provision except
So where have you shown? Let us see that averment, that there is no other provision apart from the compassionate appointment circulars, EMPs issued by you, by the Labor Department.
but why not asking the query? Query is the answer to the question.
We have asked that query in our order of 13th May. We have considered it, what are the relevant provisions in any statute, rule, circular in respect of the family members in the line of duty serving the police force. That is our query. We didn't ask you to deal with compassionate appointment.
No, but all deals with the compassionate appointment if somebody died in hardness.
It is not a case.
Kindly see paragraph 5. I'm not asking the fire if somebody died in a firing squad or during duty, what should be the consideration?
Fine. Already file a reply. They say that you did not die in the line of duty. Let us see. They say you did not die in action. Let us see.
Only
You file a reply. You file a reply. For filing reply.
opposition, they have accepted that I lied while on duty.
No, we are not disputing that.
No, you are disputing. You have said so in your reply. We will see when it is taken up. You respond, then we'll see.
July. Item number 9.
Lordship, in item number 9, I appear on behalf of the petitioner. Lordship, I will be praying for 2 weeks' time. Lordship, this matter was heard by your Lordship, and your Lordship has put some queries to us. So we have sought for instructions from our client, which
Yes.
Lordship, we have not received yet.
List after 1 week by way of last indulgence as
Lordship,
paid for by
Lordship,
Leonard.
Lordship, kindly grant us
Further
2 weeks'
time, call the
time.
next case.
Lordship,
1 week.
1 week will be 27th, next Friday. But I'm having some personal difficulty. Can it be Monday week?
All right. Give the date of Monday.
Monday week.
30th.
Respondent number 3.
10.
For this state, sir. Yes. So you? Yes, ma'am.
Today is disappearing.
Yesterday was there. Yes, yesterday.
Let's see, we are not today. We'll see what happens.
Great.
11.
I was pleased to Milord indicate.
Oh, yes, now I can see from the order we see what.
Yes, therefore, Milord, I am.
Have you moved for those benefits? For those benefits?
For the enhanced benefits. Now, why I say? Because your lordships may kindly consider that I was working from 1995. 1999, I stand wrong, Milord. 1999.
Work charged?
No, Milord,
Daily.
first of all, Milord, casual worker. Then, Milord, it was indicated as that, Milord, I am a temporary, a local, Milord, as a Darwan or guard.
Temporary?
Temporary Darwan or guard. For
Darwan, okay.
Darwan, guard.
This continues.
This continues till date. Now, only. Yes. Now, why I should be indicating to my Lord Miller only one thing. Only one thing I'd be indicating.
Yes, before you indicate this 8,500 is with effect from which date?
This is from Miller. I am showing to my Lord Miller. This from 1999 onwards. Miller, kindly see page 26. Can you read for the year 1999 onward, 8,500. No. Now, on instructions, I am submitting that, Miller, this particular amount of 8,500 was not granted to me from 1999 onwards. And that, my lords, will be pleased to find from the documents, Miller, which have been annexed.
No, it does not say to grant you with effect from 1999. The second column says date of engagement along with administrative. In fact, the last column says present remuneration wages required per month. So it is in the present.
Yes.
Means from December to, or maybe December, January 2000. December 13 or January 14, whatever it is.
Now, I have also obtained, Millard, the memorandum, Millard. This memorandum I should hand up to my lord. But
You give it back to him. You give it back to him. Yes. So I said, we said, give it back to him.
I cannot say anything more. But Millard, he Millard, went outside and told me that give me some time, I will supply them. এটা তো রবীন্দ্রনাথ টামান আমাকে রবীন্দ্র আরে আপনি
So for this benefit, did you approach them?
I have made a representation, and Millard, it appears, Millard, as your lordship though I should not refer to this. Sir, my lord, page 33, page 33, though I should not.
Page 33.
Page 33, my lord, kindly do not take me on it. It's a note sheet, but I should, I say, my lord, just দিয়ে দিতে জজ যখন বলছে যে যে ওই যে ওইটা আপনার থেকে নিয়ে আমি আপনাকে দেখাচ্ছি।
Yes, what is that citation election commission work? Notings in the file cannot be relied upon. Something versus election commission. Mahinder Singh, MS Gill. Yes, MS Gill.
In MS Gill's Miller, my lords may kindly consider, so far as subject to correction, that the principles Miller which was laid down was that when a statutory functionary passes an order based on reasons, its validity cannot be supplanted by way of
Affidavit. Yes, that was also declared there.
Yes.
And the facts were that there was some notings in the file which was also being referred.
Yes, yes.
And what the apex court held, we find here that at best these are intra-departmental communications, and see that because you have shown us, therefore we have seen all the 3 pages, a draft is placed before the authority for processing or taking consequential action pursuant to the note sheet, which draft has never been approved, letter has never been issued, and this is precisely what the judgment says.
Give me any right or a better. As I told also on the last occasion.
Therefore,
Fair to the court, I should be Miller. What is the fact of the case that I should? But Miller, I hand up to my lords. Miller, this particular Miller order that the unreported order, Miller. Miller, from internal page 8, because before that, Miller, there is a discussion of the memorandums, and then Miller, court holds, Miller, that court directs the respondents to give the grant of benefits of enhanced remuneration in terms of memo dated 8th of February 2019, 15 July 2019, 1st March 2024, with effect from the date of representation dated 29 January 2019 for enhancement. Area shall be calculated upon adjustment of the remuneration already paid to the petitioner till date
respondents are directed to disperse such area within 4 weeks from the date of communication of the order and to continue payment of such enhanced remuneration. The order dated 21st of December 21-22 passed by the respondents. Respondent number 2 and order of the learned tribunal accordingly set aside and the writ petition stands disposed. So this benefit of 1611, has it been extended to you? I think your lordship may also kindly consider this on the last occasion also I had drawn to my lord's kind attention. Then your lordship was pleased to direct me to take note of the judgments delivered by the court. Page 31, which my lord deals with the staff position of the Refugee Relief and Rehabilitation Office. From item 9, my lord will be pleased to find that Group D, sanction post 8, present staff 0. See, that is unless you have made a claim for grant of benefit of the security of tenure under this decision of the government, what direction we submit to my lords that this is a kindly see what is the nature of the work or the nature of the work is discharging. Therefore, my lord, for the purpose of deciding the matter, since there is an order, my lord, which has passed by one coordinate bench followed by my lord, that your lordship may kindly direct my client to make a comprehensive representation. That is why we are saying you will have to put this portion, as your lordship was indicating, that whether you made a prayer for enhancement of the to pay you the enhanced. Yes. I cannot. This division bench has also granted the benefit from date of representation. So therefore, my lord, after I make it and kindly specify a time period, otherwise, person Millard in the particular representation in the last page, I find Millard, though it is a Bengali thing, but the substance I can show, so I can tell you, Lordship Millard, that he's saying that he is getting 7905 rupees per month, and Millard, the ailing mother and other dependent parents, therefore, he made a prayer that regularization, I cannot make a prayer. He is a Group D employee. What do you expect? From 99, he is working. I am working. Let them make a comprehensive representation. Who would be the competent authority? Competent authority, Millard, that I can tell you, Lordship Millard, it will be. Respondent number, please. 1 second, Millard. Take 8. 3. না না এটাই কমিশনের কোথায় ডেপুটি having worked
1 second, I'm Millard, just 1 second, Millard. 2014, volume 4 SCC, page 583. Millard, I'm just handing over, Millard, kindly.
ML Kesri judgment.
583, Millard. 1 second, Millard. I appeal to my lords. This is one judgment. There are 3 judgments. I found, Millard, I had taken the pains, Millard, to in 2014, volume 7,
Yes.
223.
Yes.
This is State of Jharkhand versus Kamal Prasad. Millard, here, Millard. And he 2014, volume 4, my lords will be pleased to find paragraph 35, 36 and 42 to 45. 35, 36 and 42 to 45. সে কিছু করার নেই, সুপ্রিম কোর্ট যা বলছে এখনো করেছে, তো 2025 এ দিয়েছে জাজমেন্ট ঠিকইতে। It is the judgment of 2025. Volume 9.
No, there in that case, there is a conscious decision of the government taken by a resolution
Yes.
on 12/3/96 that all these stipendary has to be regularized. So therefore, it is in that, here there is no such decision.
I say, Millard, that after Uma Devi,
No,
because
the government is free to do. The government is not shackled by the judgment.
I am not saying, because on the last occasion, what happened, that I could not show the judgments. I told
No,
my
this is, we have, just therefore we have gone through it. But here there was that.
Sorry to disturb the time of
No,
the
no,
court,
that's all right.
but Millard, there is also another judgment of 2014, volume 7, page 223. There, Millard, 3 paragraphs, 39, 44, 47. 2014, volume 7 SCC. 223. And it is my lord's Millard who had saved me, and your lordship's Millard asked me Millard to produce the judgment. Otherwise, I was, I must Millard confess before my lords that 2015.
Regularization.
Regularization.
চন্দ্রচূড়ের judgment কি?
No, no, no.
About that.
Chandrachuri judgment is it.
Outsourcing authority. আরে এই জায়গাটার নামটা কি?
Noida.
না নয়টা না তার আগে স্টেশনটা বড় স্টেশনটা
Here also the facts are that they were ad hoc. Posts created, government of Bihar took a decision, but in view of the bifurcation, things got derailed. Therefore, the apex court said, no, everything was complete. Now you can't roll back. Yes, what did we say? He submits the
and they will not take any coercive steps. I have gone to court. They are taking Millard. Now I find most of the cases which your lordship is also taking note of, that today also I before Millard, I have just kindly do not take me amiss, Millard. In court number 14, some particular contractors of Port Trust, they came to court, said that we should be treated according to our slab. The authority passed an order that you pay more security. Therefore, I say, Millard, at least a poor man, Millard, give some little protection or some, Millard, magnanimity of my lords.
hope for any passing any order of that.
No, I am not. For a second, I am not saying. I am only saying that not to take any coercive steps.
Yes, where is the question? There is no apprehension based on any material.
Very.
Item number 12,
At least till they dispose your representation, how can they do it?
No, no, uninterrupted service and they themselves are admitting.
Yes.
Yes, my lord. I'm appearing for the petition. Yes. My lord, kindly recalls, my lord, on the last occasion, my lord, I have taken my lord the entire records. My lord, for want of my lord, my learned friend on the other side, my lord, matter was adjourned. Now, my lord, recapitulating what happened, my lord, this is a challenge thrown to the my lord order of the tribunal, whereby my lord, my application for compassionate appointment was rejected. Now, my lord, father died. Father.
Your son. Demise on?
3rd of November 1999.
From which post?
Post. Peon.
Peon.
Office of the Executive.
Application made on?
Application made on 23rd of December 99.
Decided or not decided?
Hello?
It has been decided or not decided?
But it has been decided finally, my lord, by the order impugned which was under challenge before the Honorable Tribunal. The date of the order is, my lord, 5th of May 2021. The order by the authority rejecting my claim.
Page, please.
Page 47.
Yeah. One of the civil court is after that. Second. And the learned civil judge order was communicated to them when?
The order of the learned single judge. My lord, initially, my lord, what happened in the civil court, there was a litigation. My lord,
That is what we are asking you. When did you communicate that order passed by the civil judge junior division?
Page 38.
Can you give us a date when you have communicated?
But it was communicated to them on a date of 1st of October 2015.
October 15.
No, my lord, I have not said the date of communication, but pursuant to the order, they passed an communication. My lord, on 1st of October 2015, kindly turns to page 38.
This 1st October is taking into consideration the decision of the civil court.
So, my lord, after that, my lord, they directed the department to take action for compassionate appointment. And then department rolled on, my lord, and finally, my lord, 2021, they passed the order. Civil court order pass করেছে 14 16 12
But the suit is of 2009.
Not subject to correction. 2008, 1867 of 2008.
Sure.
The order sheet is annexed, my lord, page 35. The decree is annexed.
In the impugned order, it is 1867 of 2009.
But that's typographical error, my lord. Yes, 35.
1867 2008. This is the judgment. This is the order judgment.
Yes. Judgment and the decree that page 35, my lord. Decree in the suit. Decree was drawn upon, my lord, 2014, right?
Yeah.
Decree was 2014. December 2014.
After that also you have taken 7.5 years to pass this order rejecting his claim. After the decree you have taken 7.5 years. And for this delay you want to non-suit the petitioner's claim. If there was, even after civil suit, it could have been disposed of at least 7 years earlier. Why you have taken 7.5 years? So for your delay, how her claim can be frustrated? And if we accept such submission of the state, then whoever claim you don't want to entertain, you can delay it till 50 years and say that now it should not be done. This 7.5 years is early as possible. The order passed by the authority is of May 21. In October 15, some communication shows that you are knowing about the decree of the civil court. Yes, therefore we are saying 7.5 years. December 99 to May 2015. Decree is 15. Six years, 6.5 years. Long time.
But the notification of the labor department's notification.
Not required. You have to, your belated consideration has resulted in her crossing the age. How can she be saddled with any consequence of such delay on your part? She cannot be. Hmm? They have taken? No, it is.
Other Millard, they say Millard.
Where is the finding that the financial status does not entitle her to grant of compassionate appointment? Show us.
There is no fine.
Let him have his say. We'll come. Where is that?
Notification.
Which notification? It is not in the record. No. Where have you held that her financial status does not entitle her to compassionate appointment? Where is this finding in the order? Show us. No, in the observations, page 49 does not observe anything about his income. Facts you have taken note of, but you have not made any observation on this aspect. Yes. 2013. EMP 251. 13 is 251. We have it. No, it has to be below 90% of the gross monthly salary. So where is the finding that it is below 90% of the gross monthly salary? Hmm? We don't know. There is no finding. No, there is no consideration on this aspect. Eligibility you will find in clause 6.1. The monthly income of the family falls below 90% of the gross monthly salary. So we don't know whether it was below 90 or over 90%. That fact has not been considered. 9,225. What is that in terms of percentage of the gross? There is nothing. Therefore, see, the only issue is whether overage can be held against her. Therefore, even if she is not overage, even if it is not to be taken against her, then on other parameters, they has to be considered. Otherwise, he has to be fit for grant of the bond. That we are not going to say anything on that. But so far as overage cannot, yes.
Thank you. 13 and 14, my lord, I appeal for the private respondent number 1, my lord, who has got the order from the learned tribunal. But I will be seeking sometime, my lord, the petitioner is in, the respondent number 1 is in, my lord, Maharashtra. I have to seek my instruction from him. So, my lord, if your lordship kindly fix up any day, my lord, next week or thereafter, my lord.
Oh, two matters have been listed
Yes, my
now.
lord. One by the Paschim Bengal Ayurvedic Parishad, one by the state.
You are, in this case, you are for respond number?
One, my lord, the person who got the order from the learned tribunal.
You have not assailed the order.
No, my lord, I am the recipient of the order.
No, there are two.
It's by my Paschim Bengal Ayurvedic Parishad, another is by the state.
Okay.
13 and 14 are
The learned counsel representing the
Seven July.
no order.
So, আমি respondent 1. আমি দিয়ে দিচ্ছি।
Or we can have it in judgment form. This order. Judgment. Give decision on this one. That cannot be 15. I have one. And 16. 16.
একটুখানি চোখ তাহলে আমি হতাম তারাবির আমার তোমার কাছে অ্যাফিডেভিট অফ সার্ভিস সিনিয়র তো ওদিকে থাক সিনিয়র কে এদিকে দিই আর কবে শিখবি দেশে কাটা হবে দিদি
It is the order passed in OA 109 of 22.
page 75
75. এদিকে আসবো।
না তাই করে
কেন করছো
Yes. Number my submission is number one, no res judicata applied as per section 22 of the Administrative Tribunal. Number two, section 20.
Civil Procedure Code will not apply. So res judicata does not apply to writ proceedings also. So, no, principle of res judicata will apply. Finality of decision is a basic principle. So that will apply. That is immaterial. Yes.
Number two, if I consider it that res judicata, then the principle of res judicata is the party to be the same, the issue to be the same, and the issue to be decided earlier. Two-way application filed by not the same person. The first way application was filed by the deceased mother,
Yes.
and the second way application was filed by the son after demise of his mother. Then question of res judicata does not apply. And my lord, kindly have a look into Lord, page 29. Sorry, my lord, page 16 first. Lord, the applicant name is Srimati Dhani Soren. Page 16, my lord. This is the first OA application. And my lord, the second OA application is, my lord, page 60. 60, my lord. Rameswar Soren is the OA applicant. My lord, how the res judicata will be applied? Number one. Number two, Lord, in pursuant to the direction by the tribunal, in earlier OA application, my entire pensionary benefit and everything had already been released and disbursed. But the interest part is not given in that order. Therefore, the issue of interest not being decided in the earlier OA application. Therefore, my lord, in the second OA application, we paid only the 18% interest for delayed payment. And that should be paid by the company.
Yes. Where is the provision in the DCRG rules regarding grant of interest? We'll hear you. Yes, you come.
Right, sir.
19A.
My lord.
What is the provision regarding grant of interest on gratuity?
I don't have DCRG scheme, my lord.
Hmm?
Today, I don't
Go through it. Yes. Not today. Come tomorrow. Monday.
Sorry.
And 17.
Right, the instructions will have to appear on behalf of the petitioner. Millard, after going to the writ petition, I think Millard some more facts, Millard some more elaboration Millard is required. Millard, we have a written instruction Millard from the client. Millard for Millard withdrawal of this and Millard to file Millard afresh. Millard with some Millard more fact. Millard which are Millard unfortunately missing Millard in the writ petition, which are important and
Transfer order from sorting from
Millard, there is a reason why. Millard, at my instance, Millard, there is a proceeding initiated for Millard my sexual harassment at the workplace. Millard, there was a committee constituted.
The Learned Counsel.
I appear for the state respondent.
Appearing on behalf of public service.
Commission.
And let me produce the order impugned. That was passed by the West Bengal Administrative Tribunal on none of the issues were agitated in the writ petition has been addressed.
Yes. At the very outset, the learned tribunal, my lord, had committed mistake. Lordship may kindly come to the second page of the order impugned. Only one sentence I shall be drawing your lordship's attention. It's very first paragraph, 1, 2, 3, 4, fifth line. Page 2, fifth line. The sentence is applicant belongs to unreserved category. He has proceeded with the fact that he has belonged to unreserved category. And in my case, he is kindly come to page 36. Page 36, my lord, of the way. In my way, my lord, page internal, page 3, 5, page 36, subject brief. In the middle, lordship will see the petitioner is a reserved candidate under SC category. And he contested as an SC category candidate. And my lord, there was one post of SC category reserve out of 3. And that has not been considered whether the SC category candidate, my lord, as an SC category candidate, I have a better birth than the person who has been given appointment. Kindly, my lord, come to, this is a first point. Authority, the tribunal, my lord, without application of mind, the tribunal proceeded with that in this fashion. Score pattern, page 65 of the petition. My lord, kindly look for once. What should be the score pattern for appointment in the post of principal of a college for MP8, BP8? So how do the score pattern? Page 65. Page 65 at the down the middle. Total 100 marks. Total 100 marks. Academic background is 20% out of 100. Research performance based on API score and quality of publication, assessment of domain knowledge and teaching skill 20%, interview performance 20%.
Where is your admit card or anything? Have you annexed any admit card or something which was issued for the process? Call letter, whatever, anything?
Call letter for appearing in the interview?
Yes, something like that.
Oh.
We just want to see that you are a SC candidate.
SC panel gache.
So the advertisement of the public service commission is at page 63. That is the advertisement. But the call letter possibly is not part of this.
application.
The advertisement of the Public Service Commission, page 63. Now that I have shown the marks, my lord is on the first point.
If that point is established, then nothing else is to be seen. Therefore, we are asking, then the tribunal will have to consider.
List of candidates recommended for appointment of 3 posts. My lordship will get here at page 73. এটা এসসি ক্যাটাগরি ভ্যাকেন্সি, আমার নাম কই? সি, আমি সি কোথায়?
You are Arpit Pradhan.
No, keep it Monday, my lord. I shall come with that particular document.
Why? Let us see. Come to this.
This is a
Schedule of
document, my lord,
interview.
all-
Come to page 70.
Yes, my lord. নাম কই আমার?
SC.
SC, yes.
Yes. Factual premise is wrong. Tribunal should reconsider. Pleading is complete before the tribunal.
Final order of the trial.
Hmm?
Annex, that is the final order of the trial.
But it is good. Consideration is on a wrong premise altogether. Where is the question of? Huh?
No, not application of mine. Hurriedly
I
done.
think that might be a typographical error.
But both that
Is it? Let us see. If you can make out, show how it is a typographical error. What is the last cutoff for SC candidate? Let us see whether it is 52.877 or not.
That I have to take instruction because
No, it is recorded in the tribunal's order.
that is a your category. Tribunal is written by that is your.
Yes, see the RTI reply. See the RTI reply. It is part of the record. In that you have disclosed the marks.
Your lordship is on the second page of the impugned order. Belongs to your category. That is wrong. Yes.
Where is the RTI reply?
RTI reply.
Wherein the marks have been disclosed?
Maybe RTI application page 77. Reply doesn't work. Or reply. Reply. The application. পত্র আনো না কেন?
That's instruction answer, but that instruction doesn't contains the category of the category.
The respondent number 11 is the SC candidate who has, my lord, kindly come to page 12, my lord, I have stated. Also at page 8.
Take to verification.
They have submitted the application. Yes, they have made a calculation. Let me see if this claim is correct. This will not reverse the বলা এপিআর নাম্বার বলা আছে তো ইন্টারভিউ নাম্বারটা কোথায় ব্যাংক কস্ট এনিথিং টোটাল but the selected candidate belongs to SC category. No, one selected candidate belongs to SC category. If your lordship comes to page 8 once of his application,
SC category কিন্তু UR category.
see vacancy.
Page 8 of
SC candidate, but page 8 of the petition itself. So the subparagraph 11. Number 10 and 11 I just placed. Petitioner having better marks in API score and academic qualification than the private respondent number 11 who has been selected cannot be deprived to be selected in the said post of principal. However, the respondent authorities could have disclosed the respective marks with position as per merit of the candidates. Then next para, that the private respondent number 11 selected for the said post for SC is not better candidate than the petitioner. So admittedly, this respondent numbers 11 selected, he is also SC candidate. So
so he is making a inter-se assessment with the SC candidate.
Yes, that's what I'm.
The writ petition.
খেপে খেপে বলো না ফাইনাল হিয়ারিং করছো তো আন্দাজান দিয়ে দেখে দেখে দুম দাঁড়াক্কা বলছো
You can't stop her from saying.
no.
We can stop her. Please, yes, what do you want to say? Tell us.
Rejoinder before the tribunal.
Page 100. Yes. Which paragraph? Yes.
Question application is responsive and not measuring the fact of influence in WSR. So for the post. As the applicant failed to secure the marks from the scheduled caste category candidate in section, his name was not given. Applicant secured 421 marks, and the marks are only in scheduled caste category. As such, his name was not recommended by the commission for the said post in question. It is in our reply also.
This has been recorded in the order under challenge.
There might be
It appears to be, maybe, let us see.
May I give the score sheet to your lordship?
No, nothing that was not on record.
Yes, on record. 85. Page 85.
And vacancy was only one lordship.
Serial number 7 is the person got the appointment and SC category, and I.
How do you know? How do you know that it is serial number 7 is the person who got the
That is also, my lord, indicated. Lordship will get it at page 70.
70?
70. Clearly that the status of the candidate, that the same has been drawn to our notice by the lordship. According to the serial, 8 candidates, my lord, have been indicated there.
No. How do you correlate the two? The person who has been appointed in your category at page 85, he is at serial number 7. 7.
Application number.
Serial number 7, application number 9. And application number 9 at page 70 is SC candidate.
Yes, yes. Page 70, my lord, application number 9. Page 70, there is application number 9 is a
SC candidate. And here also 52.8.
marks. It is not disputed by me.
Where have you said in the writ petition that this consideration is wrong by the tribunal? It has wrongly.
The petition itself.
You have said that it has considered you as a UR instead of SC category. Where is this statement in your writ petition?
That is in the very first. That has been stated just now. I indicated to your lordship that in the tribunal application, my lord,
we are again asking you in the writ petition,
yes,
where have you stated
very first
that
paragraph.
that instead of SC you have been considered as UR by the tribunal?
But I have stated that I am SC. Very first paragraph.
That is not what we are asking you.
Lordship is asking me why I have stated that I have been
Considered as UR instead of SC. Where is that statement in the writ petition?
That amendment is not there.
So therefore, now let us, what other grounds you want to say? Tell us.
My ground is, my lord, lordship may kindly look at the tribunal application itself, where we have said the API marks. API means is, my lord, academic performance indicator.
Yes.
Which is the basic of selection.
All right.
In paragraph the present writ petition, lordship may kindly.
Paragraph
9
of
page 15 of the writ petition.
No, OA. Come to OA. We are not going to look into the writ petition.
Qualification of the petitioner has been given in OA page 6, internal running page 37.
Yes.
The petitioner is PhD and MP8.
All right. So that is.
My lord, the advertisement, my lord.
That appears to be technical.
Finally, look at the advertisement page 63 for once.
Yes.
Page 63, advertisement for recruitment.
Yes, we have gone through it. What do you want to show? That table.
Very opening paragraph.
Yes.
Ability to read, write, and speak in Bengal. An essential qualification for the post of service. Bengali. This is the whole one. But I have specifically averred the person who has been given appointment has no knowledge in Bengali, neither can write and no ability. Therefore, I wanted to, my lord, have the examination papers produced before the court. Original papers. In order to, my lord, satisfy my grievance that this person is having no qualification. Kindly come to, my lord, paragraph page 8, paragraph 9. Roman 9. Of the way that one recommended candidate Badesh Ghosh being respondent number 2. Badesh. Badshah Ghosh has no knowledge to read, write in Bengali, which is very much essential criteria for selection for the post of principal of the Government Training College, West Bengal. Not only that, his selection was previous, that his selection previously in 2007 was rejected under the same cause of action by the Public Service Commission, West Bengal, as he has no knowledge of. Still, my lord, that person, my lord, even if, my lord, I have not been segregated to be a SC candidate, I contested for the post, but this person, my lord, has been given appointment who has no knowledge in me. Paragraph 10, I have said, in Roman 10, that the petitioner having best marks in API score, 900 marks I got, but the person, second one is 600 or odd ones. Private, and the academic qualification that the private respondent being so and so be deprived to be selected in the said post of principal. However, the respondent authority could have disclosed the respective marks with position as per merit of the candidate. Post has not been private respondent number 211 and 212 selected for the post are not better candidate than the petitioner. Petitioner criteria depend upon the especially upon the API score and academic score. I have a research scholar, I have given the journals which carry marks. Other candidates have no journal to carry marks. Academic score of the candidate, but in the instant case, the marks of interview differ the merit of the candidate. Interview only, my lord, given the higher marks.
That's all.
That's all.
Yes, take down. Counsel for the